You're scrolling through your phone at midnight, and you see a terrifying letter from a county sheriff. Someone sued you over an old business debt, a car wreck, or a botched contractor job, and they just won a massive judgment against you. A judgment is simply the official court order saying you legally owe someone money. Now you're staring at the ceiling, terrified that tomorrow morning, the county sheriff is going to show up, throw your furniture out on the front lawn, and hand your front door keys to the guy who sued you. Can a lawsuit really take your house out from under you? We're going to walk through the exact hour-by-hour timeline of what happens when someone tries to take your primary residence to pay off a court debt. Keep in mind, every single state has its own unique set of rules for this exact process. This is a general simulation of how the legal machine actually operates. We're going to follow the entire chain of events from that terrifying piece of paper all the way to the moment the other guy actually gets paid. It starts when that judgment becomes official. The judge signs the paper, or the jury signs the verdict, and suddenly you have a legal debt that you can't just ignore. But the person you owe doesn't automatically get your house keys. First, they have to find your stuff. They send requests to your banks to find your cash. If they can't find enough money in your checking or savings accounts to satisfy the debt, they start looking at bigger assets. That's when they look at the county property records, see your name on a deed, and decide they want a piece of your real estate. Once the other side decides they want your house, they don't just call you up and ask for the keys. They have to use a specific legal mechanism called a lien. A lien is a legal claim against your property that acts like a giant padlock on your title. It says, you can't sell this house, you can't refinance this house, and you can't transfer this house to your kids without paying off this specific debt first. To get that padlock on your property, they take the judgment back to the county clerk, pay a small recording fee, and file it against your property address. You might not even know the lien exists for months. But let's say the debt is huge, and the person who sued you doesn't want to wait for you to sell the house in 10 years. They want their cash right now. They want to force a sale. The legal system doesn't let them do this instantly. Instead, they have to go back to the court and ask the judge for an execution. An execution is a formal court order that commands the local sheriff to seize your property, sell it at a public auction, and use the cash to pay off your court judgment. The sheriff can't just kick your door in at 3 in the morning. The county sheriff starts by officially serving you with a notice of execution. They'll hand you the paperwork or tape it securely to your front door. The notice gives you a very strict timeline. It tells you that in exactly 30 days, the sheriff is going to hold a public auction right there on the courthouse steps to sell your home to the highest bidder. The clock starts ticking immediately. But before you start packing boxes, you need to know about the most powerful shield you've in your entire legal arsenal. It's called the Homestead Exemption. A homestead exemption is a specific state law that protects a certain dollar amount of your primary residence from being taken by creditors to pay off a judgment. The exact dollar amount varies wildly depending on where you live. In some states, it protects $50,000 of your home's value. In other states, it protects $100,000 or even several $100,000. And in a few specific places, like Florida and Texas, a homestead exemption can protect an unlimited amount of value in your primary residence. If you live in a state with a massive homestead exemption and you have $100,000 of equity in your house, the people suing you simply can't touch it. The law completely blocks the sheriff from forcing a sale. But let's simulate what happens if you live in a state with a smaller exemption. Let's say your state protects $25,000 of your home's value. One of them eventually wins the auction with a bid of $30,000. You might think they just hand this guy the keys and you're instantly homeless. That isn't how it works. The winning bidder doesn't get a free house. They have to go to the bank, get a mortgage, and bring a check for the full $200,000 to buy the property outright. So where does that $200,000 go? The sheriff takes that money and distributes it in a very strict legal pecking order. First, the sheriff pays off the original bank that holds your mortgage. They get the $150,000 you owed them. Second, the sheriff pays you the $25,000 for your state-protected homestead exemption. You don't lose that money. Third, the sheriff pays the person who sued you the unprotected equity, plus their auction fees. If you don't have massive unprotected equity, the whole auction is entirely pointless for the guy who sued you. If the house is worth $200,000, but you owe the bank $210,000, your equity is zero. You're upside down on the house. The person who sued you gets absolutely nothing from this auction because there's no extra money left over after the main bank gets paid. Because of that simple math, a lawyer will rarely ever force an execution sale on a house unless they know for a fact there's a mountain of unprotected equity sitting there waiting for them. Even if there's a little bit of unprotected equity, the lawyer knows there's a massive risk. Real estate auctions are strange. The investors might not show up that day. The winning bid might come in surprisingly low, right at the minimum bid. The guy who sued you might spend thousands of dollars advertising the sheriff his sale, paying the newspaper to run the legal notices, and paying the auctioneer fees, only to walk away with a tiny check. You walk away with your homestead cash in your pocket, and you still have to find a new place to live. This reality usually stops the legal process dead in its tracks. Once the lawyer realizes the math doesn't work in their favor, they usually abandon the house idea entirely. They just leave the lien sitting on the property. It just sits there on the county records. It accrues interest. They wait patiently for 5 years or 10 years. They know that eventually you'll want to sell the house, or you'll want to refinance your mortgage to get a better interest rate. When you go to do that, the title company will find the lien. You can't close on the sale until you pay off the lien in full. The guy who sued you knows he will eventually get his money, so he doesn't bother dealing with the sheriff. If you're facing a massive judgment right now, you need to understand that the timeline we just walked through is exactly why you should never just bury your head in the sand. The legal machine moves slowly, but it moves with devastating efficiency. Every single state has completely different rules regarding how much cash and property they protect from creditors. This is exactly where you need to stop guessing and get a local consumer protection attorney on the phone. A local lawyer can tell you exactly how much of your home is protected by your specific state laws. There are legal maneuvers your attorney can use to negotiate that judgment down, set up a payment plan, or even file a specific type of bankruptcy that legally wipes out the judgment entirely and removes the lien from your property. The law gives you a massive toolbox of options, but you have to pick up the phone and use them before the auctioneer starts taking bids on the courthouse steps. Understanding this timeline gives you the power to breathe tonight, sleep in your own bed, and make a rational plan instead of panicking over a piece of paper. Has a debt collector ever threatened to do something that sounded completely illegal or impossible to you? Tell me about that phone call down in the comments below. If this breakdown gave you the actual mechanics of how a lawsuit attacks your property, pass this video along to a coworker or family member who might be losing sleep over an old court case. And make sure you subscribe to Scribble Law so you always know the exact rules of the game before a debt collector tries to use the legal system against your home.